Okay, we're here with Chuck Meyer, and he's running for Judicial Court 410th. And I am John Wertz. I'm here with Bob Bagley, Dale Fessenden, and Ken Vaughn. And so we're going to turn it over to Chuck, let him introduce himself and why he's running for this office.
Thank you. I appreciate the time and the efforts that you all put in to vet the candidates in all the different races that you're reviewing today, or have been reviewing over the past week or so. Let's see. I think I put on the form that the reason I'm running for public office is I want to engage in public service in a meaningful way that, and I'll extend on that, that maximizes my return to the community, some of the benefits that have been bestowed upon me. And I am an attorney, but I'm more than an attorney. I'm also a businessman. I've been an engineer in my life. And I would like to see the 410th be predominantly civil law bench. But I would also like to see the court system be able to use my expertise in criminal law that I've developed over the past few years as an assistant district attorney for Hardin County. It's, I don't know where you are, and given how active you are in politics, you're probably very aware that the court system is under stress in Montgomery County, not because we don't have enough judges, but we don't have the right types of judges, the right mix of judges. We have 4 judges, and when I say judges, I'm talking about judicial officers at the county court of law or at the district court level who can handle family law matters. But we only have 1 district court judge who can handle civil matters. And in the ecosystem that is developing from Exxon's move here, from Anadarko, CB&I, Lane Christensen, and other publicly traded companies, and all the companies that feed off of them, we're seeing more and more disputes, particularly between companies, between suppliers and manufacturers or service companies that need to be resolved within our court system. And we have a backlog. Judge Wood cannot do it on her own. Judge Mays had a partial civil docket. But none of the other judges are either willing or able or feel comfortable handling civil trials, or they're doing their level best to get rid of the backlog or the potential for a backlog in the various criminal courts. And I believe that I can contribute to an efficient judicial system here in Montgomery County so that our civil litigants don't have to wait for a year for a trial or for a long period of time to have their matter resolved through settlement in that trial. I come to this race, as I started to mention before, in a little different position than other candidates. Most are either a full-time prosecutor, a full-time criminal defense lawyer, or a full-time trial lawyer. I'm a business lawyer who has litigated some in the past, but that is not my focus. I believe in counseling clients to avoid trial when at all possible, and when I was the chief legal officer of BlackBerry, as you'll note from the resume, which you should have, I sent that along. I spent a lot of my time managing outside litigation and directing litigation strategy. And I do not believe that you have to be an associate judge or a civil litigator to be an effective judge. And that was confirmed to me by some of the judges that I've been talking to who currently sit on the bench. I'm the type of person that likes to do my own research and talk to the people involved in the system and try to truly understand what the problem is. And maybe I'm hearkening back to my engineering days where before you can fix a problem, you have to understand what the problem is, and you can't rely upon someone telling you what the problem is. At least I have to see it with my own eyes or hear it with my own ears. And I believe that this bench would definitely benefit from someone who has an interest in civil litigation matters. It looks like I'm almost out of time, but also has some expertise in other areas that come under the jurisdiction of the district court, namely criminal law and a very minor area, election law. The district courts are the ones that are charged with enforcing the election laws in this state. And although there aren't many matters involving election law, that is an area in which I do have a little bit of expertise, which I'm happy to go into later in response to your questions.
Okay, great. So you mentioned a little earlier in your opening that you'd like to see the 410th primarily civil because of all the businesses coming in there, and you think there will be that kind of demand.
Yes. And that there is already, we are seeing that demand.
Mm-hmm. And it's not getting processed through right now?
It's not getting processed through because there's only one judge dedicated full-time.
Who is that?
Judge Wood, Carol.
Oh, Carol Wood, okay. Yet we have 600 to 700 pretrial folks in lockup right now.
Sure.
Because of that backlog.
That's correct. And those, if I may interject, you know, those criminal defendants, as well as the state, is entitled to a speedy resolution of that.
Right, they're not getting that right now.
They're not getting that. And we're spending money, perhaps needlessly, to house the inmates. But I interrupted your question.
No, that's okay. Well, yeah, hold on just a second. And we are. The thought is, you know, by several judges and attorneys. So if you go specialized in civil, and there's talk about the
35th.
Actually, talk about this court, maybe going family.
And that,
how?
that to me, well, and let me clarify that I don't want,
You know, we're
Texas
lay people, so we're not in the
let me
courtroom all the time to know what you see. Explain what is the better way to go. I mean, is it family, is it civil, and then we got all this backlog with criminal.
It's, let me give you an analogy. My second cousin, once removed, played for the Philadelphia Phillies. He was a utility player. He played shortstop, he played second base, he sometimes played in the outfield. He had a very successful career for the Philadelphia Phillies in the 70s. We need some people to be utility players. We need some people to be pitchers, catchers. We name the position players, a particular position player. And so let me take that analogy and bring it into this court system that we have here in Montgomery County. We have 4 judicial officers who can do family law. I do not believe, and the Texas Constitution clearly states, that these are courts of general jurisdiction. And that is the position that I hold. The only reason that the Ninth, to take a different court, is considered a criminal court is because Judge Case was a criminal lawyer. When Judge Edwards was on the bench, he heard civil cases, he heard criminal cases, and presumably he heard family law cases. You have to rank the priority of the cases you have to deal with. Constitutionally, we have to deal with the criminal cases first. So what comes second? I'm biased to believe that because the civil court docket currently only has 1 judge in that area, and the family law docket has 4 judicial officers that can process that stuff, those that are wanting a divorce should stand behind those that have a contract dispute or a tort matter. That civil matters, generally speaking, should go at least in parallel, if not ahead, of family law matters. There is one school of thought that says courts are more efficient if they're specialized. I've heard folks down in Harris County where they have statutorily mandated specialized courts, that the efficiencies they thought they were seeing, they do see some, but there's a trade-off in that they have a lack of flexibility. So if they need a judge that can come in and hear a criminal case, they can't steal it from the civil bench. They have to rely upon the criminal bench. I want to be the judge that can hear civil cases predominantly, criminal cases as the need arise, because this ebbs and flows. You may have a bulge of criminal defendants that need a speedy trial. And I don't have any expertise in family law. So why would you have me hearing family law cases when there are 4 other judicial officers that have that expertise? I mean, that should be, it would be like putting my cousin in the Phillies in the I don't know, as catcher. It just, could he do it? Probably. But he would probably play at a level that would be equivalent to college or, you know, minor league baseball. And yeah, could I do it? Sure. But there's such a steep learning curve in that area. Whereas there isn't as much of a learning curve for me in the civil area or the criminal area.
Okay.
So,
All right, Bob.
So talking about making decisions for on the bench, I've got 2 favorite judges from the past, John Devine
okay.
and Ted Poe.
Okay.
Both of them went outside the box to sentence people.
Right.
One of the big ones, I've had friends that have been killed by drunk drivers. I don't think the sentences are always sufficient. I don't think that the individuals that are sentenced, it carries on throughout their life like it does for the people that are left behind, or that have been left behind for the ones that are deceased. But there's 3 crosses on the corner of 1314 and 336. A judge was very wise to make this decision, but a young teenager ran a red light, not on a cell phone, not, just ran a red light and killed 3 people.
Was he intoxicated?
No drugs, nothing, just ran a red light, just wasn't paying attention and ran a red light. We've all done it, but it was tragic in this case. Part of his sentence was to make sure that this area that's ground, it's not hollowed ground, but somewhat, is maintained every year, every month, all the time. If it's not, he goes back to jail. That's a constant reminder for this young kid that's now in his mid to late 20s, that this is something that he's paying for 20 years. Do you see yourself making out of the box judgments in this case?
You're talking about the penalty phase,
Right.
the punishment phase,
Right.
which I feel a little more comfortable talking about. As you may be aware, under the Code of Judicial Ethics, we're not permitted to talk about how we rule in any particular case.
Right, I'm not
Generally
asking.
speaking.
Right.
But I just want to make sure that we're talking about the punishment phase.
Right.
I have a lot of time for Judge Poe. I followed him when he was on the bench. I remember him sentencing a woman to wear a sandwich board and her being entered for like petty theft or shoplifting. And I remember her being interviewed saying that it's the worst punishment possible, but it really, it'd be jail time, but it was not something she'd wish on anyone else, and it really made an impression on her. I would say that, to sort of use your phrase, straight out of the box, going on the bench for the first time, I need to get my grounding and understand the expectations of the citizens of Montgomery County as to whether or not they are prepared to see a Judge Poe here in Montgomery County. I'd like my career progresses, to be similar to Judge Poe and have the punishment serve as a reminder to the person that what they did was wrong, they owe a debt to society because of what they did was wrong, and have that punishment maybe be an alternative to jail and reserve jail for the more severe felonies, etc. Particularly with younger people, I often wonder if when you have a young person, you put them in jail, if they learn more bad habits, whereas if you do something similar to what you were talking about or what Judge Poe was talking about, then maybe that's a better corrective measure. I will do what the citizens of Montgomery expect and want, and if they want a straight-up judge that provides that consistent sentencing between individuals and not having nuanced sentencing, that's probably how I'll start out. And I'll make an effort to try to convince those that don't believe that you should have particularized sentences that take into consideration factors other than what the statute normally provide. That's the direction I'd like to head, but I'm not going to do it when I'd be adverse to the population without taking a I don't know, somehow sampling the opinion of the populace or participating in educating the citizens that look at what Judge Poe did, look at that particular instance that that judge did, that's a highly effective means of helping a criminal defendant return to society something that he has taken away. Now, you'll never bring back those lives, but you are correcting behavior in a unique way. Hopefully that addresses your answer.
Thank you.
There are a number of questions on the questionnaire where your response was declined to answer.
Mainly because of canons of judicial ethics. I can go through each one if you would like and explain the reasons why. I would say 80 to 90% of them were because I believe you were asking questions that would lead me into areas in which I would be discussing how I would rule in a particular class of cases. I was read through the canons of judicial ethics. We as lawyers typically don't have reason to read them. We have our own set of ethics rules, and I was surprised at how broad the language was. And I was also surprised that a judicial candidate can be disciplined by the bar, whether or not you become a judge, if you run afoul of those. And I tend to be conservative when it comes to those things. I take ethics very seriously. I was the prosecutor of honor code offenses in my law school. I am a member of the Center for Legal Ethics here, and it's something that needs to be on the minds of every attorney and every judge. So with that caveat, if you want to go through the ones, if there's one that you particularly want to know the answer to, I can tell you why I did not answer it. And if it doesn't fall into the category of legal ethics, then you can get at least an understanding of why.
First a comment, and then I'll
Sure.
just highlight one in particular. A couple years ago, we did have a incumbent who had no problem answering all the questions, who was running for Court of Appeals. I believe it was 9th District, so it's not a entry-level court type of situation.
Sure.
And
And
freely answered all of the questions that we had. And so let me see if I can find one that maybe doesn't quite fit the exemptions or exceptions that you're talking about. Number 13, which says, where do you perceive the greatest corruption exists in Montgomery County courts?
that one was not a legal ethics one. That one is, I'm ignorant or oblivious as to what you're talking about. I need a little bit more of a, can you give me an example of what you would believe is corruption? I am unaware of corruption in the sense of someone stealing from the populace. If that's, when I think of corruption, that's what I typically think of, you know, someone filling up their car at the sheriff's office and they're a judge, you know, with gasoline. So, on that one.
That certainly could be one example. There's the number of examples are endless.
Okay, well, and
So-
I confess.
And
that
you're unaware of any examples?
I'm unaware, well, it depends on how you define corruption.
You're a lawyer, you define corruption.
Well, I gave you an example of one type of corruption. I'm unaware of any examples of corruption. And I'd be very, at least as I define it, if you told me that, you know, a judge ruled in a particular case to benefit any member of the county, any officer of the county, whether it be the district attorney, the county attorney, the county judge, that may or may not be corruption. It may just be the way the case was resolved. But again, I'm not aware of anything. And if you're making reference to the Corley jail, I have never delved into that matter. I probably should as a taxpayer, but I'm unaware of the relationship to the court, to the jail, and that whole process. So I'll leave it to you to give me an example.
You can.
Okay.
I may come back to it
So-
next turn.
I want to be educated about it, and I'd be happy to talk to you about it, but I can't respond and tell you how I would have done anything differently in that particular case, if that makes any sense. And then you do start going into it. But the reason I declined to answer that one is I'm unaware of any corruption.
Okay.
So you've made reference to the ethics issue a
Yes.
couple of times already. It's clearly evident in your questionnaire. You can answer quite a few.
Right.
Do you agree with the scope of the Ethics Act? Do you think it's beneficial? Do you think it's harmful? Do you think it should be changed? And why?
Well, that's a good question. One, not one that I contemplated answering. Let me give it a little bit of thought before I give you an off-the-cuff answer. I think that one of the provisions that bothered me was that a judge cannot serve as an arbitrator or mediator. And I'm okay with that outside of the court room. My experience, having worked for a federal judge and a state Supreme Court justice, is that a lot of times when you have settlement conferences, you're essentially acting as an arbitrator or mediator, more a mediator than an arbitrator. And it explicitly says that when you are trying to settle a case, you are not to act as an arbitrator or mediator. And I haven't had time, since I've read through these rules, to really understand why that is in this state, when other states encourage their judges to get the parties together, and sometimes there'll be a settlement judge who's not involved in the case. And you're sitting as a judge in a trial, and you say, now, go see Judge so-and-so, and see if he can't get you to resolve this without going to trial. I think that it's a very effective tool to have another judge give an assessment of a case in camera, outside the scope of the public, in order to settle particularly civil disputes. You know, it's not particularly effective in criminal matters, because plea bargaining is in the province of the district attorney, and the judge has very little role in that regard. So that is one area in which I want to do a bit more investigation, in which I, quite frankly, think that it's not the best approach. That it ties the hands of the judges to drive cases to settlement rather than trial. Judges in Texas like to try cases. I'm perfectly happy to try a case, but I'm also happier if we don't have to impanel a jury in a jury trial, and if the parties can resolve it. Now, I know Judge Mays, and I suspect Judge Wood has told parties to go to outside mediators, but wouldn't it be nice to be able to send it to another judge and say, get this resolved, don't tell me anything about it, what you said to them, don't taint me when I'm the trial judge, because if they don't settle, I don't want to be influenced by what transpired in that mediation, just as an outside mediation doesn't come back into the court, generally speaking, either, so.
Okay. We're about 30 minutes into it, and we've got about 15 minutes or so, and then we'll go into closing.
Okay.
On to number 8, among the 9 justices on the Supreme Court, you'd mentioned the one you
I mentioned
respect
2, I
the
did.
most.
I mentioned 2 actually, didn't I?
2, yeah, I'm sorry, 2 that you respected the most, but you avoided the one you respected the least.
There's probably four of them that are usually in the minority,
Okay.
I respect the least. But I have a difficulty, I come from a tradition in which, even though you disagree with the judge's philosophy, you don't say that you don't respect a judge. And it's a little hard for me to say that I don't respect a justice of the United States Supreme Court.
Okay, what about, let's rephrase it then, the one that you,
That is least likely,
Disagree with most.
yeah,
I would say that Justices Kagan and Sotomayor would be the 2 that I would pick, to be followed by Justice Ginsburg. They happen to be 3 women on the bench, but Justice Kennedy sometimes shows some instances in which he gets it right from my perspective. So, now having said that, there is a court case out there in which some of those judges were on the majority side, in which I think they actually got it right, and Justice Scalia didn't get it. But those cases are few and far between.
There's actually recently been a 9-0.
Yeah. And I've been so wound up in this campaign and my work that I haven't had the luxury of really paying attention to Supreme Court cases. I know when I'm on the bench and I'm faced with a constitutional issue that I'll be doing some legal research or having someone do legal research for me. But for the most part, there are cases that come out of the Supreme Court where 90% of the time I would be siding with Justice Scalia and Justice Alito, probably higher than 90%, and other times I'd be siding with the rest of the justices, but those are few and far between. and it's on very minute, nuanced points. It's not, would I be on the side of Justice Roberts on Obamacare? No, I most likely wouldn't be. I don't want to edge too much into how I would rule, but I'm not being vetted here to become a Chief Justice of the Supreme Court either. So
You should be able to speak freely on that.
And there is an opinion from Justice Scalia that talks about regulations on judges and judicial races, which I'm very much in favor of. I wish that I had greater freedom, or perceived that I had greater freedom than I do. I'd like to be in the position of that Court of Appeals judge that you spoke of earlier. I just take a more cautious, conservative approach when it comes to these matters.
Okay, as an elected official, you don't have to put in any particular amount of time. when you're serving.
That surprised me.
I know. Judges, for the most part, when I've been to the courthouse, a number of their doors are closed on Fridays. A number of them are closed in the afternoons. They're locked, the lights are out. Do you believe that you should be putting in at least a 40-hour week and your staff as well?
Yeah, yeah, the simple answer is yes. I found it peculiar when I've been up there as well. You are, to some degree, required to be on duty 24/7, but as I found out this past week, you need to be available for warrants on a rotation basis for 1 week out of a month, so 24/7. And part of the issue may be that people don't realize what you're doing when you're not in the courtroom or not in your chambers. I'm a virtual lawyer. I do not have a brick and mortar office. I have an office in my home that I work out of. I have conference room rights. You know, you could say he never shows up to his office. Well, because I don't have one. And I'm happy with judges that are putting in the effort, and I would like the flexibility of being able to take my work home and work on it. But there's no way for the public to know that that's what I'm doing. I began my quasi-legal career as a patent examiner, and we were required to work 40 hours a week. But we were also required to get through so many patent cases. If I had a particularly difficult case that took more time, I couldn't necessarily make it up in the next case. I had to put in the time, and it meant that I was staying longer than 40 hours in order to get through my required docket. And so the measure of time shouldn't be, is it 40 hours, 60 hours? It should be whatever it takes, you know. Do we have a backlog because judges aren't working? Or do we have a backlog because we have more cases than the judges can handle? Or do we have a backlog because we have cases that judges refuse to handle because it's not their area of expertise? I don't know the answer to that. All I can commit to you is, I worked for a tech company. We worked 40 to 60 hours. I don't think we ever worked 40 hours a week. We worked 60 hours a week because you got the job done. And so if I'm not as efficient as other judges, and it takes me 60 hours to get the job done, then I'll put in 60 hours. And it's as simple as that.
Okay.
Okay, you mentioned one particular topic twice. Once on question 16, you intend to make oversight of the county auditor an important part of the campaign. And
Okay.
again, in question number 4, as far as what you believe the significant issues are, what role should the court play in oversight of the county auditor? Would you please elaborate on that? What do you think the proper role is, and why do you think that oversight is needed?
Well, I know as a matter of law that the judges appoint the county auditor. I also have heard that there is no oversight of the county auditor once she or he is appointed. I know I've heard rumblings of disappointment in our county auditor, and that, I believe it's a she, is it not? That she is not as effective as some of the populace wishes her to be. Before I make any comment as to whether she should stay or go, I need to understand, and I haven't dug deeply into this, what traditionally has been done, what we're entitled to do under the statute in terms of oversight. We should be exercising to the maximum extent oversight over the county auditor if that's what the statute calls for. I need to look into allegations that have been made or rumors that have circulated that she's ineffective or too beholden to certain interest within the county, and not as a judicial matter that would come before the bench, but under the part of the statute that says what the powers of the court, the judges are with respect to that position. And I cannot sit here and tell you today that I've finished learning everything there is to learn about that, but it's an area in which most judges, when you run for a judgeship, most judges don't pay any attention to it. A lot of people don't even realize that, or if they do, they don't care, that the judges appoint that person. That's probably the most important person for protecting our taxpayer money in the county.
Let me ask one brief follow-on question.
Sure.
Though the time has expired. Is that specifically entrusted to the 410th? Why not the 9th? Why not the 4th?
No, it's all
all judges.
it's all the judges together. It's all the judges together.
Okay.
But I want to remind the other candidates in every race that that's a collective responsibility of the judges. And it's not one that needs to be put at the bottom of the list behind the judicial responsibilities. That's an administrative, sort of executive responsibility of management of the county auditor. And if the statute actually says that the judges can exercise more oversight than I believe they've done, then I would advocate that we assign one judge to report to the rest of the judges and exercise that oversight. But I haven't looked at the statute.
Okay.
And once I do, I'd have a better answer for you.
All right, so my last question about
All right,
the,
satisfactory but not especially good.
No idea where that came from.
Well, I thought it was the
It's
camera.
on.
It's off.
my last question regarding the Judicial Ethics Act.
Sure.
Interesting answer. Wasn't the specific area I was interested in.
Okay.
Specifically, I'm interested in, you're running for, we elect judges here in Texas.
Mm-hmm.
We elect judges, we have to know who the candidates are.
Sure.
And then we constantly get this answer back that, well, I can't actually tell you how I'm going to rule. But what are we electing to do? To make rulings. So you're basically telling us, well, I can't tell you how I'm going to do my role in office.
Well,
Do you believe that is ethical? Do you believe that the law is, in fact, correct or wrong? Why is that the ethical ruling?
I think you have to have a strong rule so that judges continue to maintain some level of impartiality. If I came in here and said that I will give a stiffer sentence to people that wear blue shirts than people that wear red shirts, that is, well, no, I won't go there. That is not something you want your judges to do, to not be impartial.
But how would that be any different than a judge ruling every single time someone's wearing a red shirt, him saying, you're guilty, and then running for office again? Everyone knows he's going to rule guilty on that.
But, at that point, there are two remedies to that, which you want to start out with the judge at least appearing impartial and appearing to be ethical. And if they run afoul of the ethical guidelines, then they're disciplined by the Judicial Ethics Commission. Or, in really bad cases, I believe you can be removed by impeachment in the state of Texas. But I certainly know that you can be sanctioned by judicial ethics. And then finally, every 4 years for this position, it will come up as a campaign matter. Just as it's come up.
Well, no, but it can't, because we can't ask how we're going to rule.
No, but you can certainly, you certainly know how that person is ruled because of their track record. I mean,
Right, so any existing judge, we know.
Yes.
But any new judge, you have no idea.
But what you do know, which is, I believe on there, and it was on one of the vetting forms I filled out, is my judicial philosophy. I'm a strict constitutional constructionist. You know, I believe in a textual, literal interpretation of statutes. I don't believe that you should insert your opinion of what the law should be for what the law is. And that covers pretty much, should pretty much cover everything, you know?
And that's pretty much exactly what Chief Roberts portrayed himself to be. And then we get something completely different.
Well,
Because we can't ask detailed questions.
Um,
So why even elect judges if we can't ask simple questions?
Well, I mean, there's a lot of debate, and a lot of states don't elect judges. Other states have judges appointed and then sit for retention elections, which is sort of a model I like. But then you have the potential for cronyism, and at least here you have a say on which judicial candidate's judicial philosophy you like. It's not as though we can't tell you that how we view cases. It's not as though you can't hear from me as to how I view alternative sentencing type things. Each case has to stand on its merits and its facts, and it's sort of the judicial equivalent of malpractice for me to say, if this fact occurs and this fact occurs, and the statute involved is this one, then the person is guilty beyond a reasonable doubt. Or, that's not the best example, let's take it on the criminal. Then the civil plaintiff will win 99.9% of the time in my court. It's just, each case has to be taken on its own merits, and I've seen way too many times that one particular fact can switch a case
Sure.
going from one party to another. And to anticipate all the different permutations and combinations of facts, I mean, we can go through the list and I can...
But the question is, do you believe that you can't discuss those sorts of details?
I believe that you can't...
Do you think it's appropriate for you not to be able to?
I believe my reading of the canons of judicial ethics and my understanding of them and talking to other judges precludes me from talking about...
That's a fair statement. My question is, do you believe that ethics code
Yes.
is ethical?
Yes.
Okay.
I'm just not certain I can articulate easily why. I guess I look to the alternative in which judges have free reign. What I'm interpreting your question to be is, how can we get greater transparency into how a judge will rule on a class of cases? Or in an individual fact situation. And I don't know how you structure a rule that reminds judicial candidates and judges that each case is unique. You can't go into a case with a predetermined mindset that I'm going to...
Because the populace can't be trusted to understand that each case is unique? Are we that stupid?
Well, what am I going to say to you? If each case is unique, how can I comment on any particular class of cases?
Well, because we're an intelligent populace that can say, well, we understand it's a simple question being asked, and you're giving us a simple answer. To say we can't answer anything because, well, it might be misinterpreted. I mean, I can look at any existing judge's past rulings and say, well, that's where he rules on that particular case, and yet you can't talk about how you would rule in that case, because that would distort everything.
Let me tell you the approach of the other, and maybe you're aware of this. Have you seen the vetting form for the Patriots Pact?
No.
They ask a question that somewhat addresses this.
Mm-hmm.
They asked me to provide them with 3 to 5 judicial opinions that represented, that I was fond of, or that represented my judicial philosophy or something like that. And I provide with an opinion from the District Court of Hawaii where I was a judicial clerk that involved private property. And I provide them with an opinion about one of the few instances in which the Supreme Court has actually relied upon the 10th Amendment. I wish I had it with me here, and I can send it all to you, but Patriots Pact didn't say I couldn't share it with anyone. I'm willing to share it with you. That provides you a little bit more insight into my thinking. Because if I like those cases, then presumably I like the outcome in the cases. One of them was a dissent by Alito in a case. And so that can give you a little bit more insight in a particular fact pattern that gives me the comfort that I'm pointing to another judge's decision and saying, that's the way I like the outcome in that case, and you can extrapolate from that, that's probably how I would rule in situations involving private property. That particular case involved taking an ancient Hawaiian fish pond that had been the private property of when it was no longer an ancient Hawaiian fish pond, that was in the hands of a developer. The developer opened it up and made it a lagoon, and the issue before the court was, when you connect it to the ocean, does it become part of the navigable waters of the United States that the United States government can exercise jurisdiction over? And it was a bench trial, non-jury trial, in which the judge for whom I worked as a judicial law clerk assigned me the task of drafting that opinion, which was published. I can demonstrate to you, if you saw the opinion, how you knew I was involved in the case, because the footnote on the first footnote is the first three words are my initials. It's one little thing that judicial law clerks do. One time during your career with a judge, if the judge let the draft go through, you put your first initials, and then that's the one opinion for the time you're with the judge that you can point to and say you draft. So I would encourage you, and I can send you the site to that case if you're interested in my philosophy on personal property rights. But most everything, all those cases boil down to reading literally the statute, looking into the legislative history of the statute if the statute's not plain on its face, understanding the contours of the U.S. Constitution, and in our case the Texas Constitution, as to any particular matter. And more than that, that should give you the answer to how I'm going to be in 90% or more of the cases. I just cannot think of any particular instance in which you would not have the answer if you understood how I'd be applying the rules on the bench. I mean, sure, there's probably some fantastic set of facts in which relying upon those 3 or 4 things won't give you the answer as to how I'll go, but it's probably a case of first impression, which means a case that has never been decided under a particular statute, and in which there's no particular guidance as to how the statute is to be interpreted, and the statute's ambiguous. But those should be few and far between. So I'm happy to share with you that, and if you still have questions, I'd be happy to address it, but I think it's sort of what they say about jury trials. It's the worst system except for every other one. It's an imperfect system, but it works at some level. And sitting down and talking with me about the periphery rather than particular cases that might arise is fair game. But it's just when you start going down into areas in which the Code of Judicial Ethics seems to indicate, and I believe it does indicate, that would be not a good thing for me to discuss. I mean, there's a clear bright line. If you say, hey, my friend Joe just got arrested for drunk driving, and they didn't give him a breathalyzer test, and they only charged him because he was walking funny and his eyes were going back and forth, you know, and you don't think that he should have to serve time for being a drunk driver. I mean, that clearly is something I can't respond to, because Joe might be in my court, or Jane, who has the same fact pattern. You know, and also, it'd be the jury that would determine that, not the judge. So, it's a long-winded response, and well over the
A little over 2
time.
minutes. One more question, and then we'll go to closing. Probably as important as knowing how you're gonna rule is something you alluded to when, in question 7, describe the best way for the average voter to determine which judicial candidate is best. And that is not only intellectual capabilities, but judge's temperament.
Mhm.
Going back a little bit of history, and when you went and presented before the township,
Mhm.
it can be said that some people probably considered you a hero in what you did, and some people probably not so much when you confronted the township.
Some thought I was being disrespectful, and we can go into that. But
Yeah,
if you,
yeah.
that's
So-
fair game.
So how do you, if you kind of step back and look at yourself from a 40,000-foot overview as a potential judge, to be fair and impartial, how do you kind of reconcile those two? I mean, what's your kind of opinion now that time's kind of gone by a little bit?
At the risk of you thinking that I have multiple personalities, there is the political me, there is the citizen advocate me, and there is the judicial me. And it's unfortunate that we do elect judges if you have to be a political me to be a judge. I'm striving very hard not to be a political me to become a judge, because I think that it's I don't want the public to have the perception that because I'm a conservative Republican, if you're a liberal Democrat, you're not going to get a fair trial, a fair shake in my courtroom. Or because I am a Christian of a particular faith, I happen to be Roman Catholic, that if you are not a Christian of my faith, that you will not get the same ruling that someone who is a Christian of my faith will get. So in terms of the township board or any of the outbursts that I had during the course of the election, that's a demonstration of passion and sometimes frustration. And in the case of the township board, to me it was a matter of integrity. And one thing I take very seriously is, if people say they're going to do something or act in a particular way, and I would say to you to hold me to this standard, then have the integrity to do what you say you're going to do. Have the integrity to not politicize something that, and in terms of township board, I don't know if you heard my words, because you had to get them out there rather fast, and I came across as angry more than intellectual or cerebral or cool-tempered. But I didn't say that they shouldn't have voted to oppose the road bond. I said they shouldn't have voted one way or the other if they had questions about the interaction between the Patriots PAC and the county judge, particularly while there was a criminal investigation outstanding. To me, the two lawyers on the board, John McMullen and Bruce Tuff, in my view, as lawyers, should have known better not to comment on a situation that's under a criminal investigation as a public official. That's my belief, and I expressed it that evening. Would I care if and the other part of that, which I couldn't get into, is the agenda item said consideration of a motion to support the bond issue. That's what the agenda item said. So what's the public think? That they're going to have a motion to support the bond issue. They substitute a 180-degree motion, a motion to oppose the bond issue. Now, where I stood on the bond issue is irrelevant to the fact that they said they were going to discuss one thing, and if someone wanted to support the bond issue, they're thinking, well, they're going to support the bond issue, why show up, to support the bond issue? And then when they turn it at that meeting to be an opposition bond issue, then the populace that wanted them to support the bond issue probably wasn't going to show, probably wasn't there to a large degree. And the situation, if it had been flipped, where they had a motion to oppose the bond issue on the agenda, and then they switched it to a motion to support the bond issue, I think that a lot of people would be equally upset that they said they were going to discuss one thing and they were going to do another. And so, I guess I'll go back to what I said earlier. If you say you're going to do one thing, then give the populace a chance to respond if you end up doing another. And don't, and I probably shouldn't get into this because this is really the political me talking, not the judicial candidate me talking, but I believe that the intentions of the board members there had very little to do with the actual bond issue, but more to do with the particular persons and entities involved. And they were trying to take a swipe at the county judge and the Texas Patriots back. And they found it a convenient way to do so. And I just don't necessarily think that's appropriate. So.
Okay. All right, so why don't you take up to 5 minutes for your closing, and then we'll wrap it up.
Again, thank you for your time. I hope I've answered your questions as fully as I felt comfortable under the Judicial Rules Code of Ethics to be able to do so. If you'd like to explore further any of my particular answers, I'd be happy to go point by point down them at a later time, or by email or by a phone call. I want you to get to know me on behalf of your great organization to the extent that you can. I bring to the table a strong intellect, and I will not apologize for that. I've been gifted by the great Lord above with an ability to decipher problems that others do not have the ability to do so. That may sound arrogant, but as Brandon Creighton said the other day before the Republican women, if it's true, it's not arrogance. I want to use my intellect to address the problems that we see in the court here. And I am well suited to be a decision maker, to be an umpire, particularly in civil matters, but also in criminal matters. And if the need arises, I can learn. My brain, even though I'm nearly 57 years old, is still flexible enough to learn new things. I just think that it would be a waste of my other areas of expertise to have me have a significant family law docket. I'm the only candidate in my race that has an advanced degree in law. I am not a specialist in the terms of the Texas Board of Specializations, but I am a specialist in that I'm a licensed patent attorney, which is a specialty. And the reason the Texas Board of Specialties does not have that as a specialty is because there's a separate licensing system, and it would be meaningless to have it as a specialty because you're licensed specially to be a patent attorney. So when other candidates say that they are board certified, well, I'm essentially board certified by the United States Patent and Trademark Office as a patent attorney. Not that any patent matters can come before this court, but the decision-making process of trying to determine, as I did when I was a patent examiner, whether the facts of a particular invention means that when the law is applied that a patent will issue. It's a similar process. You're looking at the facts of the case, and you're making a decision based upon what the law is. It's a quasi-judicial rule that I had back in 1985 to 1989. So I will also say that when I clerked for the federal judge in Honolulu, I was assigned to be a hearing examiner in an employee matter, where we had an employee that was potentially being disciplined, and they needed to have someone hear the case under the administrative system of the federal government and get it all on the record. And I was very proud of the fact that the judge turned to me and allowed me to play the role of essentially of a judge in that particular instance. I've also been, part of my pro bono work is to be a judge in an international commercial arbitration court competition where you judge various law schools competing in that moot court competition. And it's essentially, it doesn't matter what type of law it is, but the skills of being able to look at a set of facts, apply a set of rules or laws, and come to a conclusion or a decision. It's the same. And it has many aspects similar to what an engineer does, or what a businessman or woman does, in determining what the appropriate pathway would be. And I think it's time that we have someone on the bench who is able to solve problems in a variety of ways and comes with a mindset of a businessman. I was an executive with the BlackBerry Corporation, as you may know from the resume that I submitted. I was their chief legal officer, and I started BlackBerry Europe, a startup within a startup. And I had to make decisions based upon the facts that were presented to me on a daily basis. And we need someone who has been more than a trial lawyer or more than a family law judge to sit on this bench and make decisions, particularly in civil cases. And fortunately, I've had some experience on the criminal side, and I can do it there as well.
Okay, great, thank you very much.